David Dellinger, John Freunds, Lee Weiner, Bobby Seale, Rennie Davis, Tom Hayden, Abby Hoffman, Jerry Rubin.
Stay in Chicago, and we're going to grow in Chicago until Tom is out of jail, until Wolf is out of jail, until the Indian who is walking down the street is out of jail, and until there is safe for the people again.
The movement's belief is that what we want corresponds to the real needs of everyone who's oppressed, that there is a sense in which we are the people. And that's hard for us to believe, and harder to work from. We came to Chicago fearing isolation.
What do we want? Revolution! Now! What do we want?
Senator Dirksen, Mr. Chief Justice, Mr. Vice President, President Johnson, Vice President Humphrey, my fellow Americans, and my fellow citizens of the world community. I ask you to share with me today the majesty of this moment.
Well, after the convention in '68 in the summer, there was divergent views. The right wing in the country, such as the House Un-American Activities Committee, accused all of us of being communist sympathizers, and that's why we were in the streets.
There were two investigations undertaken. The first one was by Lyndon Johnson's Attorney General, Ramsey Clark, and he essentially determined that what had happened in the streets of Chicago was a police riot. Sure, the police were egged on by demonstrators, but their response was totally out of proportion to the provocation that they had gotten. Then, with the election and Richard Nixon taking over, his Attorney General, John Mitchell, conducted his own investigation and came to a very different conclusion. He saw this as a riot provoked by radicals, and the administration was out to get those radicals.
You know, Nixon was vice president in the 50s during the reign of Senator McCarthy, who saw communist conspiracies everywhere and indicted people for being communists. And I think Nixon followed that model when he became president and wanted to invent a conspiracy, but a conspiracy also would appeal to Americans who are prone to that kind of fear. And so we were indicted as the Chicago 8 conspiracy, which became the 7.
A lot of these people who were indicted, like Abby and Tom Hayden, Dave Dellinger, Rennie Davis, Jerry Rubin, had been activists for many, many years. They had been subject to illegal national security wiretapping. Everything in their lives was the subject of surveillance. These were the enemies of the Nixon administration. And so when they were indicted, they realized that this was war.
I thought we were walking into a trap, no question about it. I guess all I thought was, let's make a plan. What are they charging us with? How do we defend ourselves? And we want to work on two levels. One, the courtroom, and two, the level of public opinion. Because if there's a verdict by public opinion for us, it will influence the whole outcome.
The Chicago 8 faced two different charges for the most part. One was the charge of crossing state lines with an intent to start a riot. Note, that's not intending to start a riot, it's crossing state lines with an intent to start a riot. It's what they were thinking when they entered the state of Illinois that mattered. It's a very strange sort of crime. The other was conspiracy to cross state lines with intent to start a riot, which is an even stranger crime in some sense. And two of the defendants, in addition to that, faced charges of teaching the use of an incendiary device.
I don't know what you mean by vandalizing, but as for taunting, I've never been told that taunting is illegal. What we're accused of by many people in the government is precisely this business of taunting. Like, somehow we'd get a fair trial if we dressed up. Last year, we wouldn't have been attacked by police if we had called them Mr. If we had shaved and had short hair last year, it would have been a peaceful scene. And this whole issue of taunting becoming a crime is very apparent to all of us.
On the question of whether the defendants actually intended to start a riot, perhaps the best comment was made by Norman Mailer when he said the defendants understood that you no longer had to attack the fortress. All you had to do was stand outside the fortress, make faces at it, let the people have a nervous breakdown, and destroy themselves.
A normal criminal trial, a crime occurs, and who did it? And they get the person who they think is responsible for the crime, charge them, and there's a trial. This is a group of people, let's find a crime to charge them with, because it's political. And that's exactly what happened. And the anti-riot statute, crossing state lines with the intention of inciting a riot, give me a break. I mean, they crossed state lines with the intention of protesting, you know, the war.
David Dellinger, Tom Hayden, for example, were very politically focused. Their main objection was to the administration's policy in Vietnam. They were just strongly anti-war. On the other hand, people like Abbie Hoffman and Jerry Rubin, their objection was really that the administration was anti-fun. They were more culturally focused. Their objections, their gripes were wider spread than just the Vietnam War. And then you have someone like Bobby Seale, whose main complaint was really that America was racist. And although he had sympathy with the anti-Vietnam movement, he was really more concerned about what he saw as racism in America.
We were not selected randomly. We were selected as symbolic leaders of different trends in the movement, the Black Panthers, the anti-war movement, and the Yippies.
And the government, in the indictment, decided to lump, you know, those different segments of our movement together. I remember on arraignment day, Bobby Seale, who had been indicted, who had been in Chicago one day and just flew there to make a speech and went home. When he was indicted, we were all in the courthouse. We had a council room. We were preparing to go into the courtroom, and he was asking everybody for their business cards, and he thought Dave Dellinger was one of the lawyers. Dave Dellinger was his co-conspirator. It was absurd. And that's why it was so political, because the Nixon administration chose, you know, 8 people who barely knew each other. I mean, 1 or 2 knew each other, but it wasn't a group that acted together, and accused them of being a conspiracy. And it was a way to put your enemies on trial.
After several references to the Black Panther Party, and with it known that the chairman of the Black Panther Party is one of the defendants, the judge said in his attempting to be inimitable manner, referring to the Black Panthers, he said, if such an organization exists, I say that this proves that either the judge is too ignorant to be on the bench or too dishonest, because he was making a clear allegation that he did not know that the Black Panther Party existed. The Black Panther Party has been attacked throughout this country. It's become a political issue in the city of Chicago itself, reported on the front page. And I would like to know how it happens that the judge in this trial considers himself both competent and honest, but is unable to ascertain whether or not the Black Panthers exist.
The judge assigned to the trial was Judge Julius Hoffman, who is an arrogant, snobbish, rather prudish individual. And more than anything, he had a reputation as being a strong pro-prosecution judge, pro-government judge. It's pretty obvious when you look at the trial transcript that Judge Hoffman had little sympathy for any of the defendants. He was in his 70s himself and clearly did not identify with these individuals in the slightest. His rulings almost always favored the government. For example, when the government tried to introduce evidence that related to statements made by the defendants before they entered Illinois, he admitted those into evidence. When the defendants tried to do the same thing, he said, no, you can't admit that into evidence. That would be self-serving. So he did not treat the two sides equally. He also denied many attempts by the defense to introduce certain evidence, like testimony by Attorney General Ramsey Clark relating to his findings of the riots. So time after time, the rulings went against the defense and in favor of the prosecution.
Our lawyers, for example, can't even cross-examine a jury. You know, the judge asks them all the questions. I don't think that we are going to be tried by a jury of our peers. Bobby Seale feels that he can't be tried by anybody that isn't black. I feel that I can't be tried by anybody who hasn't been on LSD, you see. Dave Dillinger and Rennie Davis, they feel that they can't be tried by people who are in support of the war in Vietnam, but we can never be tried by a jury of our peers.
There was a commentator who said that the jury selected in the Chicago trial resembled sort of a rolling prairie bowling league or something, not the sort of jury that would really be sympathetic to the defendants in a case like this one.
They weren't asked questions about their views on the war. They weren't asked questions about their views on cultural issues, the youth culture, the Abbey, the Jerry. It was, who were they? I mean, nobody knew who they were.
The defense had asked to have about 50 questions asked of each of the potential jurors. These questions were designed to find the kind of jurors who might have some sort of sympathy for the defendants. Questions like, do you know who Jimi Hendrix is? If you have a female child, does she wear a bra? Would you let your child marry a yippie? These kinds of questions were designed to find some jurors who might have some sort of sympathy for the defendants. Judge Hoffman said, we can't have any of those kinds of questions asked. And in fact, of the 50 questions that the defense asked to have asked, Judge Hoffman asked exactly one, and that was a question of whether you have some sort of connection with the police department.
There were a bunch of lawyers from all over the country, activists like myself, Bill Kunstler, Lenny Weinglass, Michael Kennedy, Dennis Roberts. You know, there was maybe 8 or 9 of us at different stages. And we all came together because the clients brought us in. Bobby Seale was represented by Charles Gary of Oakland. Bill Kunstler, you know, had a long-term relationship with either Rennie or Tom, I forget. I had been representing Abby for a while, you know, so we all came together.
We go forth as human beings to remove these pigs, these hogs in the power structure, murdering and brutalizing people not only here in the confines of racist, decadent America, but murdering and brutalizing and oppressing people all over the world. That when we go forth to deal with them, that they're going to always send out their racist, scary, rotten pigs to occupy the people, to occupy the community, such as the way they have this park here occupied.
Bobby Seale was included as a defendant in this case by the prosecution, probably because he made the most extreme statements that were made anywhere in Chicago. Some of his statements were indeed very shocking. And I think what the prosecution hoped is that those very extreme statements by Bobby Seale might taint the other 7 defendants and make it easier for them to get convictions of those defendants.
Bobby Seale had Charles Gary as his lawyer. Charles Gary had represented Huey Newton. He was the lawyer for the Black Panthers in California. I was the lawyer for the Black Panthers in New York. And Bobby Seale wanted Charles Gary to represent him in the Chicago 8, but Charles Gary had a gallbladder operation that was scheduled in September when the trial was scheduled. And he went to the judge sometime over the summer and asked to adjourn it so he could have the operation and come back. The judge wouldn't hear of it.
There came a squabble over whether Bill Kunstler could be or should be Bobby's attorney. It was very confusing. Bobby said no, but he had signed a document. Kunstler said, no, if Bobby doesn't want me, I'm not going to affect his right to self-representation. The judge just overruled everything, and that caused an interesting lawyer's protest. You don't see that anymore.
That day, the judge decided, since Charles Gary wasn't there and he should have a lawyer, he assigned 4 of us to represent Bobby Seale. We had never spoken to Bobby Seale about his case. It was an absurd, ridiculous order, and we refused to comply with it. And we were thrown in the clink.
And you've come here, I assume, to ask me what happened yesterday. And my answer is that yesterday I was jailed by the judge of the Northern District of Illinois, Judge Julius Hoffman. I was jailed on an order of contempt along with Michael E. Tiger of Los Angeles, California. Mr. Tiger is a professor at UCLA Law School. He has also issued arrest warrants and contempt orders for 2 other attorneys who are in the Northern District of California, and their names are Michael Kennedy and Dennis Roberts.
The lawyers in the country erupted. The entire Harvard Law School faculty signed a petition opposing the contempt citations against the lawyers. And hundreds of lawyers flew to Chicago on that Monday morning when we were supposed to be sentenced for contempt to protest the courthouse, the judge. It was such an amazing event, the judge backed down and let us go. But it set the tone. This was at the very beginning of the trial. It set the tone for how everybody viewed this trial. While I was in jail with Bobby Seale, the government had finished their opening, and I said to Bobby, what are you going to do? You're going to represent yourself? And he said, yes. I said, it's your turn. And so we went back into the courtroom, and he stood up in front of the jury to make an opening statement, and the judge said, sit down. And he said, I'm defending myself and defending my constitutional rights.
Judge Hoffman's response was, you can't do that. Tell him to shut up, essentially, take your seat, which provoked really strong responses from Bobby Seale. Bobby Seale would hurl insults at the judge, call him a fascist dog, a racist, a pig.
And it went that way for 2 days until the judge ordered him chained to a chair and bound and gagged.
Judge Julius J. Hoffman, he thought, for example, that he was, by reputation, a strong supporter of civil rights. And he kept reminding us of that as he ordered the chaining and gagging of Bobby Seale, that he wasn't a racist. Bobby Seale was provoking his own chaining and gagging by seeking to represent himself, which the judge thought was a trick.
Everybody was so outraged by what he was doing to Bobby Seale, and Bobby's fighting for his rights. You could hear him mumbling under the gag. You know, he just wouldn't stop fighting.
Under the Constitution, Civil War Reconstruction Amendments, a black man is entitled to self-representation. That's it. You may not like it, that's the law. Bobby was well within the law.
This went on for several days, and finally it was so frightening that the judge severed him from the trial. And the Chicago 8 became the Chicago 7.
To answer everything. Yes. I mean, we're not afraid of any of your questions. We're trying to educate all the people to get out of this misconception that you apparently have about the nature of the movement. But if you remember the testimony about us in the case, all of the organization, all of the demonstrations that we're supposed to have organized, like the March on Sunday, like the March to Free This Person Hayden, all of these, according to everyone's testimony, these organized marches that we were the heads of were orderly.
Criminal trial is one in which the evident motive of the defendant is to break a law that has no social meaning. You rob a bank. Well, maybe that is social, but a political trial is one in which the preponderance of evidence is that the government is going after people primarily for their beliefs, for their value system, and only secondary for their behavior.
The prosecution case was built largely around witnesses who were undercover agents, people who had managed to infiltrate the anti-establishment movement. In one case, one was a bodyguard of Jerry Rubin, others had taken leadership positions within the anti-establishment movement.
The national mobilization, and we're sitting at the table with police. I mean, what about the First Amendment? You know, this was the height of outrageousness in terms of government activity. Their witnesses were police pretending to be protesters, you know, in order to get these people indicted.
These witnesses testified that the defendants had encouraged illegal acts like blocking traffic, taking over hotels, disrupting public events of various sorts. And main testimony of the defense had to respond to those accusations by the prosecution witnesses. So the prosecution case was really built by undercover agents who had infiltrated the Chicago anti-establishment movement.
Most of us did small things in Chicago that would have been misdemeanors. Jerry Rubin was accused of throwing a sweater at a police officer. They could have been handled as local misdemeanors in the Chicago court, local court. Or at most, they could have been they could have been prosecuted as state felonies. Why were they federal? The government wanted to try us as conspirators to interrupt the democratic process. They accused us of making it political, but how are you supposed to respond to a political attack? By saying, try me as a common criminal? No, you have to respond to the political attack with a political answer.
Revolutionaries bent on the destruction of the government of the United States of America. They're a pitiful handful. They have almost no support, but by golly, they get the cooperation of the news media. They're built into something really big. They're referred to as kids. They're referred to as yippies.
I remember Jerry Rubin had a funny take on it. He thought it was the Academy Award of Protest. He actually liked it. He gradually, and Abby, they gradually started to realize that it could be all over, that this was not theater. But they stuck to a theatrical approach. But his first reaction was more media, more entertainment. This was the beginning of this visualized revolutionary experience.
Bill Kunstler, Rennie Davis, Tom Hayden, Dave Dellinger wanted to rest after the government's case, saying it was just a bunch of police nothing. Abby wanted to put the government on trial and wanted to have a culture presented, the youth culture, which he had spent his time organizing in an amazing way. And so he wanted Allen Ginsberg to come to the stand and say what he was doing in the parks in Chicago, which was his and Judy Collins and William Styron and all of these, Dick Gregory, to put them all on the stand, to say why they were there, what they were doing. And Abby won out.
I had come of age politically at a time when media attention was just dawning. I was a classic symbol of the linear person that tried to think in logical steps. What's the goal? How do we get there? What's the work that we have to do? So I became a kind of additional lawyer, a supplemental lawyer, examining witnesses, cross-examining, preparing the defense. And I was just starting to become fully aware of how the media had turned this into an extravaganza.
The defendants had different goals in this trial. Some of the defendants wanted to play it straight. They thought playing it straight was the best way for them to get an acquittal, like Tom Hayden. On the other hand, defendants like Abby Hoffman and Jerry Rubin in particular thought this trial was a big joke. They used it more as a recruiting tool for their yippie movement than for anything else, right? They would show up at the trial, bare their rib cages, show up in judicial robes one day, eat jelly beans. They would bring a birthday cake in to the courtroom. All sorts of rather outrageous things, like blowing kisses to the jury. So they certainly allowed a circus atmosphere to develop, much to the unhappiness of some of the other defendants who would rather have seen this whole thing played straight.
For instance, these defendants were subpoenaed to the House Un-American Activities Committee in the fall of '68, right after the convention. It was sort of the same kind of show. Abby wore an American flag shirt into the hearings to say, I'm more American than you are. I believe in protest and the First Amendment. So it was those kinds of acts to obliterate the political attempts by the House Un-American Activities Committee to say you're a bunch of communists. To wear a flag shirt, his picture was on the front page of the newspapers, not some congressman accusing them of being subversive. And that was his way of dealing. He was a genius. And so those kinds of antics went along on a daily basis.
We agreed that everybody had the right to express themselves in their own way, and that meant that our differences had to be managed. But when it got closer to the end, they were a little concerned about what were our possibilities on appeal. Had we found anything in the transcript or in the courtroom that could be used on appeal? And so the more legalistic minds had a very valid role. I think the Yippies and the Bobby Seale affair made it a global visual issue and reached a lot of people while also dividing a lot of people.
I think as the public watched this trial and they saw some of the extreme antics of the defendants in the courtroom, they read about some of the extreme statements by Mayor Daley and some of the other members of the establishment. They began to see this as sort of a circus. Judge Hoffman's rulings seemed to some outrageous, to some, of course, the epitome of fairness. But I think the overall impression that developed over the course of the trial is that this is a circus going on in Chicago. This is not a trial.
Well, I think the Yippies were right, borrowing from Marshall McLuhan. They thought that the medium was the message, and acting out on television would polarize the country in our direction, or show up the older people as being absolutely clueless.
We came to Chicago because there were a series of problems: the war in Vietnam, racism, poverty, economic injustice, with which the country was not dealing through the normal presidential elections. We brought here people who were aware of the fact that to be able to vote between Johnson and Goldwater in '64 and between Humphrey and Nixon in '68 was not a proper exercise of their democratic responsibilities. We were saying it was a time when voting was not enough, when people had to demonstrate and resist and take other forms of action. And to be tried by a jury of people that is selected strictly from those who have faith in the voting process obviously denies us a trial by our peers.
The verdict that was reached in the Chicago trial was essentially a compromise. Some of the jurors wanted to acquit the defendants on all charges. Other jurors wanted to convict them on all charges. The decision of the jury was to convict the defendants on a charge of crossing state lines with intent to start a riot, but acquitting them on the conspiracy charges. So the prosecution got more than half a loaf. They got a conviction. Those who had supported the Chicago defendants were outraged at the verdict, thought this was a miscarriage of justice, and in some cases carried their anger into the streets.
The defendants had been organizing TDA the day after, what the country was going to do to respond to this illegal trial, political trial. And the day after, millions of people in cities across the country went into the streets and protested. It was an amazing time. The defendants were jailed, and in California, the students burned the Bank of America. It was really, the country was in a wild state.
The first thing that happened after we were cleared out of the court and taken into Cook County Jail was also very, very symbolic of what it was about. The first thing they did was cut our hair.
Abby Hoffman had this wonderful head of hair, and when he was taken into the jail, even though he knew he was going to get out on bail pending appeal, and they knew he was going to get out on bail pending appeal, they came to give him a haircut. It was a violent struggle He resisted with all his power. It took 6 people to cut his hair. And when they cut his hair, there was a Republican fundraiser rally, and the governor of Illinois stood up with Abby Hoffman's hair and said, "We Republicans get things done."
They issued police photographs of the 7 of us with our haircut. That was it. That's what it was about in their minds.
You know, the fact that the jury acquitted of conspiracy and convicted of crossing state lines with the intention of inciting a riot was totally irrelevant. What both sides were fighting for was the hearts and minds of the people of the United States. And after the trial, the anti-war sentiment raged in this country, and civil rights and everything else. And so that's what it was about. It wasn't about the charges.
The convictions of the defendants were overturned by the Seventh Circuit Court of Appeals, finding that Judge Hoffman's attitude towards the defense, which was sarcastic and antagonistic, deprived the defendants of a fair trial.
We were also had a second trial on the contempt of court, where we faced a lot of years in jail. And in the second, the retrial on the contempt of court charges, 99% of those charges were dropped by Judge Janeau of Maine. So the judges played an indispensable role in upholding freedom of speech. Was it too late? Well, it's never too late.
This trial affected everybody. It affected the news media. Every student was watching it. You know, all the Congress was watching it. It was a fight for the country. And it was values like, you know, women's rights and, you know, the Black movement and the anti-war movement. It was, the whole country was involved.
History does repeat. I see a lot of similarities today between the 60s and the war on terrorism. Between the 60s and the growth of Big Brother, big data. You know, the freedom to dissent, the freedom to assemble, the freedom of speech remains an issue today as it was in the 60s.
Those values are still being fought about. You know, my neighbor, Adam Silver, just banned for life a racist owner of an NBA team. Those issues are still being fought out. And war, and I mean, it's all still there. Women's rights, but that was the beginning.
The Chicago 7 trial is a trial that really encapsulates a lot of what the 1960s were about. It shows the conflict between establishment values and anti-establishment values, and it brought together a wide variety of important political and cultural figures. It's a trial that also exposed deep divisions in the American culture.
I remember, you know, before Abby died, he was on a campus. He used to do these lectures on what they won't teach you at this university. And they don't teach that stuff. And somebody stood up and said, "So what was it all about?" And he said, "You know, we didn't end segregation. We ended legal segregation. It's no longer legal to discriminate. We didn't stop all wars, but you no longer could send 500,000 troops to someplace on the other part of the globe without the support of the Congress and the country. We didn't end discrimination against women, but even George Bush," and he was talking about the father, "will have to talk about child care in the White House. We didn't change everything, but we were young, strong, and we were right."
Actually, when I've watched younger audiences watch the movie of the trial, typically afterwards, the young people in the audience say, I thought it was a good movie, but it went way overboard on that chaining and gagging thing. They don't actually have the capacity to believe that that could have happened to us in a courtroom. It's not that they're racist or narrow-minded. They cannot, it's not in their educational experience. So much for college education and the media. They don't believe it happened.